So yes, my name is Richard Pike. I'm a partner at Brody's in the private wealth disputes team, and I'm joined by colleagues Jamie Reiki, who's a senior associate and solicitor advocate, and Nikki Neal, also a senior associate here. So in this edition, we're going to discuss pitfalls for private client lawyers when cases start to turn contentious. And really, we're looking to equip you with the knowledge to spot the main red flags and bear traps that can turn a manageable but tricky private client situation into a full-blown war between family members, which no one wants. So obviously, we're looking to avoid that and try and manage those risks. So my colleague Nick is going to start by taking a closer look at how private client professionals can best manage and avoid conflicts of interest in their work, and then go on to consider the duties of professionals involved in will drafting and some of the most common pitfalls in that area. I'm then going to look at tax and some of the pitfalls and disputes that can arise in that context. Jamie is then going to turn to some of the tactics that can be employed to minimize the possibility of claims against professional advisors. And finally, Jamie and I are going to have a look at some practical tips for you when you do find yourselves involved in a more contentious situation. And some of those are obvious and some of them a bit less so. So I'll now pass on to Nikki, who's going to start us off by looking at conflicts.
Thanks, Richard. Next slide, please. Thanks, everybody, for being here today. I am going to, in the next 15 minutes or so, touch on conflicts and also some of the duties and potential pitfalls around drafting wills. So my slides are perhaps more detailed than I will actually be able to discuss today. I've deliberately made them that way so that they're hopefully useful for you to return to after today. But I just want to start when talking about conflicts. Obviously, just to say that conflict arises, as I'm sure you will all be aware, where there is when duties to two or more clients compete, or when the solicitor's own interests potentially impair their ability to give independent advice to the client. I think the private client sector, in my opinion anyway, is a bit of a minefield for conflicts, particularly where there is a dispute. And the nuances are often quite subtle, but very critical. So it is something that all solicitors should be very mindful of, particularly in the context of private client disputes. So the starting point there, I'm not going to go through those, but it would be remiss of me not to mention the Law Society rules regarding conflicts, which I'm sure you are all familiar with, but that should always be the starting point. Next slide, please. Some examples of kind of common conflicts that arise in the private client area. Um, Firstly, acting for multiple family members. I don't think it is particularly unusual in the private client sector to be acting for multiple family members and advising on succession planning strategies, etc. And you may end up acting also for multiple trustees and executors and beneficiaries sometimes simultaneously, and for the most part I think this is usually unproblematic, but these roles can, at least in my experience, quite easily clash. And I think the ability of the solicitor to provide independent advice to each party without a conflict arising is something in these situations that has to be very closely monitored at all stages, particularly where family dynamics are complex or strained. I think this has potentially got the it's got the potential to complicate professional judgment at times. So something to be mindful of. Conflict between executors, this is something that we encounter quite a lot where there are multiple executors appointed, usually siblings in my experience, and the siblings do not get on. I think here the importance of neutrality, which is something that I will come on to touch on in a bit more detail, is really something to be mindful of. And I think just clarifying at the outset that you are acting for both parties, managing the client's expectations regarding communication, which always has to be open and transparent, should hopefully enable you to manage any conflict, but sometimes that won't always be possible. So, again, something to be monitored closely. Acting for the executor and beneficiary. Again, for the most part, this um, can often be unproblematic. For example, where a surviving spouse is appointed as one of the executors, is the sole residuary beneficiary, but you also act for them in a professional, independent capacity, for example, to assist them with their own estate planning or updating their will, etc. Um, but sometimes, in my experience, interests between an executor and a beneficiary can sometimes diverge, and it will therefore be necessary for one party, usually the beneficiary, to be advised to take separate, to obtain separate legal representation. So again, in uncontroversial and harmonious executories, this shouldn't be problematic, but we know that that is not always the case, unfortunately. Legal rights. I could speak at length about legal rights. I am not going to, you'll be glad to hear, but just a reminder of the duties on solicitors, whether acting as a solicitor executor or whether as acting as legal agent to the executors. The Law Society guidance provides really useful and clear guidance around the duties on solicitors here. And I think it is clearly established that the solicitor acting for the executor has to advise those with the legal rights claim to obtain separate legal advice on their legal rights. Next slide, please. Again, acting for trustees and beneficiaries, not usually controversial, just always a requirement for any advice that is being given to be impartial. And if that isn't possible, then there will likely be a need to withdraw. Acting for the grantor of a power of attorney and the attorney, quite often you will have prepared the power of attorney for the individual, and the grantor then loses capacity, and you may then be instructed to act by the attorney. In most cases, again, that is not controversial. But in my experience, when clients do lose capacity, well, we know that attorneys have got a duty to always act in their best interests, but sometimes defining those interests can be quite fraught, especially if the client's prior wishes expressed by them um, conflict with their current needs. And this is particularly a particularly important point if there is the potential for gifts to be made by the attorney in favour of themselves, where independent advice will almost always need to be recommended. Just finally, deeds of variation. Um, Quite often a potential conflict might arise if when you're preparing a deed of variation, if you're preparing it for multiple beneficiaries whose interests might diverge. And just wanted to point out there the case of Kay's executor nominate, which I'm sure you'll all be familiar with. But it's a really useful and important judgment just regarding attorneys who were executing a deed of variation, and just a reminder that attorneys in that context have to tread carefully, even if the outcome actually aligns with the grantor's wishes, and the process has to be conflict free. Next slide, please. So again, those were just some of probably the most common conflicts that often arise in this area. And I've mentioned already the importance of neutrality, um, which often arises when you're acting for multiple executors or parties who don't get on. The executors might have different views, they might want to adopt different strategies, they may refuse to communicate with each other directly. Um, but I think establishing and maintaining neutrality in private client disputes, it's not just professional ideal. I think it is a practical necessity, but it can present practical challenges, especially in emotionally charged and legally complex situations. I think the I've just highlighted there, and I won't go through it in detail, but just some benefits of neutrality and maintaining that neutrality in a conflict situation. Um, Preserves trust and professional integrity. I think it, you know, gives ensures that clients and third parties are viewing solicitors as people that they can trust and that we're impartial. Minimises conflicts of interest. We've touched on that already. Neutrality also protects vulnerable clients, um, particularly elderly or emotionally affected clients, vulnerable clients who might be susceptible to undue influence. It should, in most cases, support fair outcomes and enable people to make informed decisions without bias or pressure. And most importantly for us as professionals, it hopefully reduces the risk or altogether eliminates the potential of complaints or professional negligence litigation. Next slide, please. So just finally, before I move on to drafting wills, just some strategies there to mitigate or hopefully altogether avoid conflicts of interest and maintain neutrality. Just highlighting initially the importance of undertaking initial conflict checks to identify potential conflicts before they actually crystallize. Define the basis of your engagement and scope. Sorry, there's a typo there. Um, but just to really emphasize there the importance of a clearly worded letter of engagement, which defines exactly what you're advising on and sometimes what you're not advising on. Open and transparent communication. Avoid side communications with one party. This can be particularly important where there are executors, as I mentioned, who don't get on and who don't want to communicate with each other. It's really important to make sure that they are kept in the loop on all communications, so there can be no allegations of bias by one client. Obtain and record informed consent. Just documenting all decisions in contentious matters can be really, really important in the event of any subsequent complaints that are raised against you. Encouraging parties to obtain independent legal advice where required. They don't necessarily need to take that advice, but it should be given. Transparency and record keeping, again, that just follows on from the importance of kind of recording informed consent, but just really important to record and clearly document any decisions that are being made, the rationale for those decisions, and just meticulously recording that information will assist if there is a complaint. Safeguards and supervision using Chinese walls or separate teams. For example, if your firm acts for more than one party, we've had situations where we've prepared wills for spouses, but the spouses have been represented by different teams, and it's been done at arm's length. So it is possible, obviously, if both parties are comfortable with that, it's important to establish that. And ultimately, if you are not comfortable that the conflict can be avoided, if you're not comfortable that you can provide independent, impartial, and neutral advice, then it may be necessary ultimately to withdraw from acting as a last resort. Next slide, please. So just in the 6 minutes or so I am just going to touch on some of the duties on solicitors in the context of drafting wills, and also potential areas of risk for solicitors in this area. Next slide, please, Rachel. So the general duty on solicitors, which I won't repeat today in detail, as I'm sure we will all be familiar with this, it is the Hunter v. Hanley standard of care test, which I've highlighted on that slide there. That will be the starting point for any solicitor, whether a private client solicitor or a dispute resolution solicitor, or somebody acting in a different practice area. There are also specific law society rules concerning will drafting, which I've noted there, which again I'm sure we are all familiar with, and they're fairly uncontroversial. Next slide, please, Rachel. Um, so whilst the duties on solicitors in the context of drafting wills are relatively clear, there are, at least in my experience, still quite a lot of potential pitfalls for solicitors in this area. Um, I think for the most part, drafting wills will often be viewed and will often be quite a straightforward exercise. Um, but in my kind of professional experience, it is often a bit of a delicate balancing act between kind of legal concepts and factors that you have to consider, the intentions and wishes of the client, and also the ethical responsibilities that we as solicitors have. And sometimes it can be difficult to balance those different things. So just looking very briefly in my remaining time at some of the common will drafting pitfalls. Firstly, failure to take full instructions. There may be assets which have been omitted. There may be specific dependents who have been omitted. I've seen wills where the residue hasn't been the provisions regarding the residue have been inadequate, so that, for example, there's not been fallback provisions which have been put in place, which have then resulted in the estate becoming partially or wholly intestate. Section 3 of the Succession Scotland Act 2016 and the rectification powers that the court now has, it can potentially provide some relief there, but in quite restricted circumstances. Poor drafting, I think, goes hand in hand with not taking full instructions, but sometimes you might find yourself looking at a will, hopefully not one that you or a colleague has drafted, where the intentions, the testamentary intentions of the deceased are just not clear, and the provisions of the will itself are ambiguous. I think when drafting a will, it, in my opinion anyway, it should always be drafted in a way where anybody, whether a lawyer or not a lawyer, should be able to pick that document up and understand the provisions of the will and what it actually does in practice. Failure to consider testamentary capacity. I won't speak in detail about this. I think Jamie will touch on this, but all solicitors should be familiar with the test for testamentary capacity, and also the Law Society guidance around vulnerable clients is also really helpful, and I think really important that solicitors have an understanding of that as well, so that it can just inform their approach if they are meeting with a client who is potentially vulnerable for whatever reason. Failure to advise either altogether or adequately on legal rights. This is something that I have seen happen over the years. I was involved in a case just last year where the solicitor had failed to inform the deceased of legal rights. And unfortunately for the deceased and really for the surviving spouse, the deceased had three children from a previous relationship, and the largest asset in his estate was his interest in a private limited company in which he had shares. And his estate was therefore exposed to a really considerable legal rights claim, which we ultimately settled. But he had not been advised of that during his lifetime. Had he been advised, he would have had the chance to make provision for it or take steps to try and mitigate legal rights. So it's something to be really mindful of. And just again, in the context of legal rights, having regard to Section 22 of the Partnership Act, if you have a client who has an interest in a partnership and that partnership owns land or other heritable assets, it's just trying to ensure that you have taken instructions or at least explained to the client how those assets will be dealt with in the context of legal rights. Next slide, please. And just finally, unreasonable timescales. I think this is quite a common complaint that goes to the SLCC about timescales for preparing wills. The two cases to be familiar with there, I've noted White v Jones and Holmes v Bank of Scotland. What's reasonable will obviously depend on the circumstances and the urgency of the matter, but would suggest reviewing those cases as a reminder. Failure to consider or advise on tax implications of the will. Richard's going to talk a little bit more about tax, but I think this is particularly relevant just given the impending changes to inheritance tax. Survivorship destinations are another common area of potential complaint when it comes to wills, particularly if, for example, the residue passes to a life rent trust. But if there is a survivorship destination and that's not been considered, that can be problematic. And just other things, ensuring the will's been properly executed and also considering connections with other countries and foreign assets, etc. as well. So that was a very high level overview. I'll hand you back over now to Richard, who is going to talk on tax.
Thank you, Nikki. Um, so yeah, the first thing you might be wondering is why we're talking about tax in a talk about disputes. Well, um, unfortunately for all of us, it's an unavoidable feature of life for private client lawyers, whether it comes to estate planning, trust work, or executory work. And that's all the more so when things become contentious. And we're seeing tax increasingly coming up, either as a dispute in its own right, or as a big feature of disputes between the parties. If I could have the next slide, please, Rachel. Um, so it's a huge area in its own right. I'm only going to spend about 10 minutes, hopefully, looking at three areas. So firstly, what are the key pitfalls and risk points you need to think about when giving or being faced with tax planning advice and engaging with capital taxes generally, and how can you minimize those risks? Secondly, if things do go wrong and there's an HMRC inquiry or a dispute with HMRC, some pointers to help you out in that scenario. And thirdly, I'm going to have a little look at when tax can become a feature of disputes between the private individuals involved in a contentious trust or executory case. So firstly, looking at pitfalls and risks, the starting point and the kind of obvious point to make here is that these taxes, particularly inheritance tax, are now fiendishly complicated. And what were already complicated rules in the first place are becoming even more so over the years as changes are piled upon changes. I mean, a good example of this perhaps is the rules around residence nil rate band, which came in a few years ago. And I can remember reading a paper by a tax barrister, and he commented that he had, I think, a PhD in maths, and he was a leading tax barrister. And even he couldn't get his head around the rules around the residence nil rate bans. So, what hope did any sort of layperson have? And as I'm sure your groaning inboxes will testify to, this complexity and planning need is only going to increase as the changes to agricultural property relief and business property relief come into force next April. And then, as things stand at the moment, pension pots will then fall into the remit of IHT come April 2027. And I think that latter point in particular is going to have a big impact on executory work, when it comes to people dying and how the estate interacts with pension trustees and deals with the tax. And I think that in itself could be a source of disputes that we need to be mindful of. Um, Again, it goes without saying that both capital gains tax and IHT can be highly consequential if things go wrong or if the right planning isn't implemented. So it's really important, I think, for private client advisors to be very careful around tax advice in terms of both whether they are the ones giving it, um, and if they are, how it is being communicated and documented. I've seen numerous cases where what was intended to be quite sort of vanilla tax planning has gone really badly wrong due to basic errors or failures in communication, and that's led to big tax bills and big litigation afterwards. Um, I think given the level of specialist knowledge that's required around tax, I think one of the main ways that everyone can help minimize the risks is by ensuring that whoever's advising the client has the right level of expertise, especially if it's really complicated. And if you don't feel you've got the right level of expertise, I think that needs to be made clear to the client, and you need to emphasize to the client the need for them to go and get specialist expertise where appropriate. And I think where things are really complicated, or if proposed planning might be a bit novel or potentially controversial, a good step that you can take to minimize risk is to consider going to the tax bar and taking an opinion from tax counsel to help protect yourself and the client if things go wrong. Um, Another big risk point, I think, is around the formality with which advice on tax is given. Um, I would always suggest trying to avoid altogether giving informal tax advice, especially in writing. Um, the real nasty things I see are off the cuff emails. So you might be in a dialogue with your client on email, as we often are these days. And if you start talking about tax in those emails, I've had experience of cases where that's had a habit of coming back to bite, and those emails might be taken out of context in a dispute or a professional negligence claim, where a tax situation has gone wrong. So suitably caveated formal advice is normally going to play out better. Um, Likewise, when it comes to meetings, if you're delivering advice around tax in meetings, I would always take care to produce your own file note that makes the advice you're giving very clear and puts in place the caveats that you've given. We're moving into a world where AI is going to start taking over the documentation of meetings and calls. And I think we need to be very wary of AI generated transcripts that could produce garbled minutes, especially about complex tax matters. So I think at the moment, perhaps try and avoid AI producing transcripts of those sorts of meetings at the moment. If it does, they need to be checked carefully by the person who delivered the advice. So we can have the next slide, please, Rachel. Now just turning to some points to bear in mind if you do end up with an HMRC inquiry or a dispute. So first of all, a word on the context here, which, as some of you may know, has changed over the last few years. I think the wider economic climate, the strained public sector finances that we're hearing about in the news on a regular basis, has upped the ante in terms of the government wanting to reduce the so-called tax gap, and that's the difference between the tax that the government believes people should be paying, and the reality of what ends up being included on tax returns. So there is a real focus at the moment on that, and the government are investing into tax recoveries. Taking that one stage further, what does that mean? Well, I think unfortunately, because of the difficulty in getting to the really sort of naughty tax avoiders, the people who might be hiding assets offshore or using international structures, I think what it means is that in order for the government to get a good return on investment, the focus is going to be on domestic high net worth clients, capital tax avoidance, pensions when they come in. So in short, I think we're expecting to see more inquiries and disputes. And so our advisors operating in this area need to prepare for that, in my view. Um, just a few pointers around if you're faced with an inquiry. In my experience, it will normally begin with questions and requests for information from HMRC. And I would urge caution on two main fronts here. So, firstly, HMRC will often ask for more information than they're really entitled to. Um, don't fall into the trap of wanting to look like you know a good boy or girl on the other side and try and give them more information that they're entitled to on a voluntary basis. That can often lead on to more questions or even HMRC taking up a new line of inquiry on an unrelated matter. So try and restrict it to what you actually need to provide. At the same time, it's really important to make sure that what information you do provide is factually accurate and consistent. If it is inconsistent, my experience is that HMRC will start to view your client with a lot of suspicion, and that will often colour HMRC's approach going forward. So if the inquiry ends up with an outcome you don't agree with, you are then going to be into appeal and dispute territory. Um, Going back to the point I made earlier, I think you really need at this point to consider carefully whether you've got the expertise to continue running with it, particularly if perhaps your firm was involved in giving the advice. Is this the right time to involve some specialist tax disputes lawyers? I think you need to also take care not to fall into procedural traps when it flips into a dispute. So, for example, once HMRC have reached their decision, the onus is going to be on the taxpayer to lodge an appeal to that decision, not wait for something to happen at HMRC's end. There can be some useful procedural aspects here too. So it's worth taking care to consider who's got the burden of proof in a scenario like this. So if the dispute concerns allegations of fraud or dishonesty, for example, then the burden of proof may well be on HMRC, which could put a whole different dynamic on the case if there's no evidence to support those allegations. A tax appeal is normally going to be fought out in the tax tribunals, usually starting in the first tier tribunal. And just as I was saying, there's been a shift in HMRC's approach to inquiries generally. So we're also seeing a shift in the approach to litigation and tax disputes. HMRC used to follow a sort of gentleman's code of conduct approach when dealing with tax disputes. We're now seeing them employ more of the sort of street fighting litigation tactics that you normally see come up in commercial litigation. So you're going to get late disclosures of documents, procedural wrangling, perhaps submissions being served at 4:59 on a Friday just before Christmas, that sort of thing. If we could have the next slide, please, Rachel. So what do you do in terms of trying to resolve matters rather than litigating them out in the tribunals? Well, there are opportunities here to pursue alternative dispute resolution with HMRC, but I think the key point to make is that HMRC are not a private party in the same way that a commercial business is. And that really restricts their ability to do commercial deals or a sort of horse trade type settlement in the way that a private litigant can. So when you're presenting a proposal to HMRC, it's really important to tie that back to the rules and the principles and the policy decisions in play. It's really worth looking at HMRC. They've got a document called the Litigation and Settlement Strategy. Have a good look at that before you consider getting into an ADR process. Um, if you can engineer a mediation or some other form of roundtable discussion with HMRC, um, it's really worthwhile considering which individuals are going to be in the room. Is the right individual, the individual at HMRC with decision-making power, are they going to be present? Because if they're not, the whole thing could be a pointless waste of time. Um, so I'm going to move on now, just before I hand over to Jamie, just to look at what I would describe as non-HMRC tax disputes. So if I could have the next slide, Rachel, on this one. Um, so increasingly in the context of inheritance and trust disputes, I am seeing tax becoming what I would describe as weaponized between the parties, particularly in really complicated scenarios, and particularly in scenarios where there might be assets in other jurisdictions or assets offshore. And this is where parties might be adopting particular interpretation of how tax will play out in the scenario to suit their own ends and to support their negotiating position in the litigation. And the basic rule here is that the more complexity that there is, I think the more potential there is for this to occur. I think the way to address it, if you find yourself in this situation, is to get some good specialist tax advice sort of separately. Or another tactic that works quite well is if you've got a reasonable party on the other side, can you persuade them to instruct a joint tax opinion so that you get one answer, and you remove that idea that tax has been weaponized. Um, I think the flip side of that, in terms of tax being used in disputes, is that I think tax can also sometimes be a useful tool in trying to resolve a dispute. So the obvious example here is an inheritance dispute between the spouse of a deceased person and the deceased person's children. Um, so if those assets were passing in part or in whole to the children, then over and above any nil rate band relief available, those assets are going to be taxed at 40%. If a dispute occurs, but it's possible to agree a settlement, and you can do that via a deed of variation within 2 years of the death, then it may be possible to share those assets out between the spouse and children without paying any IHT at all. For example, by making use of spouse relief, transferable nil rate bands, and then the spouse gifting assets onto to children on agreed terms and making use of potentially exempt transfers and insurance against those transfers. So that brings my section on tax to a close. I'm going to hand over to Jamie now, who's going to look at minimising the risk of claims against professionals.
Thanks, Richard. I think everyone who's joined us this morning will know that private wealth disputes are something that are on the rise. Executive disputes, family business disputes, trust issues, will challenges. Personally, I've gone from having maybe one or two on the go at any one time to them making up the bulk of my practice with multiple inquiries per week. And a lot of the disputes are running to a conclusion. You can look at the court's judgment website, and regularly in this field, there are now reported decisions. I've had a couple this year. There are many more that have been published. And we've discussed some of the factors around why that is. Already, perhaps more wealth, more of a sense of entitlement, more complex family structures. But looking to the future, one of the key trends that we can see coming is a rise in claims against professions. And one of the reasons behind that is that professionals are insured. And so if negligence can be established and a duty of care can be established and a loss can be established, there is a pot of money there that can be got at. And that's not always the case if trying to sue individuals. We know from the Holmes case that Nikki mentioned earlier that the court has set out that there are some circumstances in which duties of care will be owed to the beneficiaries under an instructed will. And we can see that we can foresee that people will probably try and push the bounds of where those duties lie and what the boundaries of those duties are. So what we want to think about are some things that might help either mitigate against the possibility of these claims, or at least if a claim does land, help you deal with them more effectively. And many of these things have already been trailed by Nikki and Richard, but they do underline the importance of them. So we can move on to the next slide. These are the 7 things that I just want to touch on. It's not an exhaustive list, but there are certainly things, some obvious, some less so, that will help. First thing is to try and spot the early warning signs. There are some recurring themes in these kinds of cases. We see a lot of these kinds of cases, so we're able to sort of see where these themes lie. And if you can spot these early on, you will be able to ensure that you're thinking about everything you need to think about to discharge your duties, and also take any steps you need to ensure that your advice is properly recorded and that there are good contemporaneous file notes. I'm looking at these principally from the point of view of taking will instructions, but they apply equally to other kinds of advice as well. So some of the things that might be a warning sign: lifetime gifting and loaning by the testator. If money has changed hands through generations, this can be a source of conflict between those that have received and those that have not. Quite common for money to be loaned or gifted between generations without any records being kept. I had a case like that was reported earlier this year. Without clear records being kept at the time, it might be difficult later on to show whether, for example, money was intended to be repaid to parents or whether there's no expectation of that. And whilst I don't suggest there's any duty to force your client to have these conversations with their children, or any of the other conversations that are or issues that I'm going to mention, having thought about it and given advice to the client about it, you may find that recording, having raised that, will help if an issue does arise later on. Potentially disappointed beneficiaries. Another warning sign: is their child going to be excluded totally or receive less? If so, are there good reasons for that? If there are, then recording them might be useful for the purposes of any dispute that arise later on. Blended families on the same kind of theme. Are there likely to be expectations between generations or children from different partners that are going to receive different amounts? Is there an expectation that everyone will be treated equally within the family? Is that what's going to happen? Again, raising the issue with the client, and if there are good reasons, then recording those in your file again will make it clear that these things have been thought about and the testator's instructions were followed through. Late in life changes, late in life marriage, late in life changes to testamentary intent. These things are issues or factors that play into many disputes. And again, recording whether there's good reasons for those is helpful. Another risk is business assets. Nikki's touched on those from the point of view of legal rights, the sort of claim or issue that Nikki described, where there's a big asset in the form of a partnership interest or shareholding, and that was never discussed in terms of a legal rights claim, is not uncommon. I've got a couple of them on my desk at the moment. But there's other things, other children who are working in the family business and are expected to get it all. If they're not going to get it all, has the patriarch or matriarch given cogent reasons for that? If so, it's worth recording them. If there are children who haven't worked in the business, again, are they going to be expecting a share? And if they're not getting it, if there's cogent reasons, then worth recording. Another big theme in private wealth disputes is capacity. Nikki's already touched on the different test or the test for testamentary capacity. Be familiar with these tests and be also familiar that there are slightly different tests for testamentary capacity. The test essentially that's set out in the House of Lords case of Bank against Goodfellow, which has been followed ever since, and the test in Section 1.6 for the purposes of the Adult Swing Capacity Scotland Act 2000. If you're in any doubt, seek a second opinion, perhaps from a colleague. If you're still in doubt, if you or your colleague would be uncomfortable swearing on oath that you were satisfied that the client had capacity, then that's probably the time to seek medical opinion and a medical sign-off. Medical evidence won't be conclusive of capacity. We know that from Smith against Romana's executors and some other cases. But from your perspective, it will cover you or help cover you if a claim lands that a will was prepared or a power of attorney was prepared when there was no capacity to grant it. Undue influence and facilitating circumvention fit in with that. Again, be familiar with the tests for those. Be familiar with the red flags, and where there are those red flags, think about how you consult with the client, what questions you need to ask the client, whether you need to consult with the client on their own, and record that you've taken those steps and considered all of those things. Scoping, Richard touched on this, and as in Nikki, stay within your expertise. Dabbling risk gives rise to risk claims. So be clear on what you're advising on and what you're not advising on, and what you can advise and what you cannot. If you're not giving tax advice, make that clear. Make it clear in writing in your terms of business letter or letter of obligation. And having done that, beware of scope creep later on. Don't, by osmosis or by sleepwalking, end up giving the advice that you've said that you're not going to give, because then your very skillfully crafted terms of business letter isn't going to help you out later on. And continually manage the expectations around that advice and the subjects of the advice by effective communication. I tried to find the stats on it because I know there are some, but I couldn't lay my hands on it. But a good chunk of SLCC complaints essentially come from poor communication. So having that good communication with the client will help avoid that. Good record keeping, file notes. My colleagues who act on behalf of the master policy insurers would drum this into anyone who will listen, and indeed those that will not. A good file note is good evidence if it's made contemporaneously of what was said and what was done. We also know that from Lord Glennie in the case of Smith against Romana's executors. I'm going to read what he said about file notes. In our increasingly litigious society, the importance of retaining full and detailed file notes regarding meetings with clients, matters discussed with them, particularly in relation to their testamentary instructions, and how the client appeared and comported himself or herself during the meeting should be obvious. The professionalism of the three solicitors involved should be a worthy example to all private client practitioners. What you don't want is for you to be involved in a dispute and there to be a reported decision, and for you not to get that show of approval from the judge, and instead be on the wrong end of some narky comments about the quality of your file notes. The quality of file note recording what was discussed, what was advised, what was instructed, and making those file notes contemporaneously is hugely important. Some very quick points before we move on. It's a very obvious point, but make sure documents are properly executed at the time. Much easier to sort that out whilst the testator is alive than to find out when you collect the will from the safe upon their death. Keep your knowledge up to date. Ensure you're complying with your CPD requirements, but that's particularly important in the current IHT landscape. We're all being asked to give advice about planning when we don't have all of the information, so keeping on top of that is vitally important. And beware of what duties your client might owe. If your client is acting in a specific capacity, such as the executor or attorney, consider whether they have specific duties that they have to discharge. The case of Kay's executor against Kay's former attorney plays into this. The attorneys have done some IHT mitigation by entering into a deed of variation in respect of Mrs. Kay's late husband's estate. However, they didn't consult with the nearest relatives in accordance with principles under the 2002 Act. Ultimately, the transaction wasn't set aside. There's very interesting discussion about the interpretation of powers of attorney, which is useful, but we're not going to go into that just now. But in terms of the failure to comply with the principles under the Act and the breach of fiduciary duty, the court took a very pragmatic approach, because what Sanson found was that actually what would have happened is the attorneys would have asked the nearest relatives. The nearest relatives, out of self-interest, would have said, no, I don't want you to do that. And the attorneys would have done it anyway, and it was a sensible piece of mitigation for them to do. So the transaction wasn't set aside. But it's very easy to see situations where the failure to consult would have been fatal to the transaction. It would have been set aside, and that the solicitor who had advised or failed to advise in that regard on the transaction would be on the hook for a claim. We can move on to the next slide, and then again to the next one. Some sort of general tips about private wealth disputes. We'll share these with Richard, conscious that we're getting on for time, so we're going to take them fairly shortly, but they are, many of them, fairly obvious. I'm going to talk about some points where essentially the dispute has become litigated and has positions perhaps have become entrenched. Richard's going to come in a little bit later on to discuss some perhaps cheerier thoughts about resolving issues before they get that far. So first of all, early collaboration. Never too early to get a litigator involved. Those who appear in courts regularly know the process, have a good feeling for strategy, the prospects and practicalities of a dispute. We're happy if you don't have that capability within your own firms, or you want to bounce ideas. We're always happy to have that discussion and to get involved in disputes without taking over the instruction or taking over your client. But certainly early involvement of a disputes lawyer can really help with strategy and preventing a dispute going further than it needs to. Beware prescription and other time limits. Prescription sometimes misunderstood in this arena. Prescription applies to obligations rather than the raising of court action specifically. So payment of debts, for example, the obligation to pay a payment of debt would expire after 5 years unless there's other issues that can be used to extend that time limit. The recent NBM trustee case was an example of an accounting from an attorney. That case didn't really make a decision on whether the obligation of an attorney to account to the principal and subsequently to their executors did extinguish after 5 years. Lord Brady said that there may be certain circumstances where the attorney acts as a fiduciary, and so it doesn't extinguish. It's imprescriptible. The best approach at the moment is to assume that 5 years after death, assuming the power of attorney expired on death and not sometime before, is your time limit for seeking an accounting. But there are other time limits in these kinds of disputes. Section 29 claims for cohabitant within 6 months, rectification of a will, 2 6-month time limits, either 6 months from death or 6 months from confirmation. And in these cases, it's going to be nigh on impossible and grounds for a claim if these time limits are missed. Know who you act for. We've talked about conflicts at length, so I'll not labour the point too much, but try and manage potential conflicts early, identify where conflicts will arise. The benefit to you is that if you do that and you manage the conflict early on, you might be able to keep some of the work. If you wait until the conflict has crystallised, then you might have to send everyone away and not keep any of it. Caveats, early warning system within the court, so you can lodge a caveat, as you all know, for example, to get warning of when someone seeks confirmation. Pound for pound, the best piece of legal help a client can buy in Scotland. Getting that early warning can help you with strategy, can help you take necessary steps that you need to do before confirmation is granted. confidentiality, this looks back to conflict, but again, it's considering who you act for or who you acted for and who you owe confidentiality to. If you prepared a will or other deeds and there's a dispute around them, you may be asked to produce your file or to produce the deeds. Usually confidentiality of a deceased will lie with the executor. Is anyone asking you for those documents or the file asking you in that capacity? If not, are you able to give them to them? Was the confidentiality actually owed to two people, for example, the deceased and their spouse? If so, do you need to get the authority of the spouse to waive the confidentiality and privilege as well? Have a sort of good understanding of what remedies are available, because there are some remedies that might help with early intervention and to get to a resolution without a full-blown action of reduction, for example, or seeking removal of trustees and getting into a big bun fight. A Section 4 certificate under the 95 Act, for example, to set up a deed is quite straightforward, and most part proving the tenor. And you can do that with a Section 4 certificate at the same time if you have lost a deed that isn't properly executed. Reduction of confirmation, deeds of variation, as Richard mentioned. And finally, with costs and timescales, if you're giving initial advice on disputes before perhaps they go to a disputes lawyer or at the real outset before disputes become crystallised, be realistic about the costs and timescales. Again, another big thing why complaints land is that there hasn't been a realistic advice on how much things will cost and how long things will take. If things get litigated, the cost will be large and the timescales will be inevitably long. And I'm going to hand back to Richard to wrap up with his tips.
Thanks, Jamie. Yeah, I'm just going to finish off very quickly, conscious of time, by focusing on some of the, I suppose, softer skills that I think can be just as important in helping to resolve these types of private client disputes. I'll start with the last point on the slide, which I think is really the key theme for me on this, which is good communication. Both to avoid disputes in the first place happening, but also if you get into one, then trying to resolve it. And I think it sort of goes beyond just the tone of the communication. I think questioning what you're actually doing. Perhaps consider asking questions of the other side to understand their motives and what they really want, rather than just advancing your client's position. Often it's not just about the money. There can be sort of big issues between the family it's what they're really trying to address beyond the money. So maybe putting some focus on that rather than just going straight to seeing this as a sort of commercial deal to be done, I think can really help. Have a think about the psychology of the individuals involved. Those of you that are in sort of larger firms, you may have done training on identifying personality types. So have a think about those. Is this person a sort of red alpha type individual? Are they a bit more reserved and introverted? And you can adapt your communication appropriately. When it comes to talking off the record and having without prejudice discussions, I think, again, think about the person on the other side, be frank, but also be sensitive. And finally, just in terms of mediation, which often gets encouraged as a way of sort of solve all for these kinds of disputes. Mediations are really useful in certain cases, particularly really intractable disputes that have been going on for a long time or that involve numerous parties, but they are very expensive and they can be just as expensive as a day in court sometimes. You're having to pay both sides' lawyers for a day and a mediator on top of that. So you just question yourself, is it really appropriate? Or if I've got a sensible counterpart on the other side, can we just get on the phone or get around the table and try and progress settlement discussions that way? So I'll leave it there for now. Thank you all very much for coming along. If I can have the next slide, please. Rachel, questions. We do have some questions, but I think because of the time scales, we'll have to get back to those people individually, but we will do that. And any other questions or thoughts beyond this, we'd love to hear from you. So please get in touch. So with that, I'll sign off and thank you again all for joining us today. Thanks.
Thank you.
Thank you.